then you'll be where you are now, and then you'll be going before a judge, not a jury. And if the judge is convinced to the level required by the law, you violated any of your conditions, again, the judge would grant this motion to adjudicate, just a big legal word, meaning the judge would go back, find you guilty of the offense charged in the indictment, and then you could be sentenced up to the maximum for that offense. You with me on that?
Yes, Your Honor.
Any questions for me about anything?
No, Your Honor.
All right, now, I believe that Mr. Strada mentioned it's been, and I'm not sure Marcella's on this Zoom, but when you book out of jail, one of your conditions of your deferred adjudicated probation is that you have to immediately report down to Ophelia Ramirez at the probation office. You understand that?
Yes.
You know where the probation office is, correct?
Yes, Your Honor.
Now, what I don't know is when you'll book out of jail. Theoretically, you could book out before 5 o'clock this afternoon. If you book out after 5 o'clock this afternoon, the way your term of your deferred adjudicated probation reads is that if you book out before 5, you obviously got to go straight to probation. You understand that?
Yes, I do.
That's probably unlikely. So if you book out sometime this evening, then you have to be in Ophelia Ramirez's office at 8 o'clock in the morning, okay?
Yes, sir.
Now, her computer will show when you book out. So if you book out after 5, she comes in and you're not in her office at 8 o'clock in the morning at the probation office at 8 o'clock in the morning, she'll send me another violation report and it'll trigger another no bond warrant, okay?
I understand.
You got any questions for me about anything?
No, I don't.
Anything else, Mr. Estrada?
No, Your Honor.
Anything else, Ms. Anderson?
No, sir.
All right, I'm signing this order, which is basically just adding condition 54 to his present terms and conditions. He's assigned to a level 2 intensive supervision for a term of 2 years. During this term, report each week as directed by your supervision officer, Ophelia Ramirez. I probably asked you 6 times, Mr. Rodriguez, but you understand that?
Yes, Your Honor, I do.
Okay. All right, we're in recess.
Will you let Edmonds know that I need Fletcher?
And Denise, I'm not taking that plea. Brian is. So I don't know anything about that case, and I don't have the file or anything. So I think Brian thinks that one's at 3 o'clock.
He's in the waiting room. I just have to let him in.
Oh, yay! Okay, sorry, I didn't know that.
That's okay.
I don't want her fussing at me.
All right, we're on the record by Zoom. Calls number 2410578-21, State of Texas versus ELIEL, Felicia, FLECHA. It's on indictment charging delivery of a controlled substance. Defendant appears to be before the court from the North Jail. Mr. Giral, Assistant District Attorney, is present by Zoom. I don't have Mr. Perkins yet. At least he's not on my screen. Mr. Giral, can you hear me?
I can hear you, Judge.
Okay, I've got Mr. Perkins now by Zoom. So, as I've said, 2410578-21, State versus Elio Felicia. I'm saying that right. Delivery of a controlled substance. You would go ahead and make your motion, Mr. Giral, on your indictment.
Your Honor, this is a plea hearing. So the motion is to abandon the language that's been struck from the indictment. You should have a copy in front of you.
Yes, sir, I do.
And that language should change it from engaging to just a straight delivery of a controlled substance. And I've given the court coordinators the CJIS codes, and Mr. Perkins has discussed the wording that we have abandoned as well.
All right, correct, Mr. Perkins? I'm sure it is. I think I just lost you.
That's all correct, Judge. I don't know. Let me see if I can rejoin the meeting.
There you go. There you go. Okay, you've rejoined the meeting. So now the indictment 2410578.
He's actually gone for good this time. He's going to have, just give him a second. He's signing back on.
Okay. Did I get the defendant sworn in, Mr. Giral?
No, Your Honor.
I didn't think so.
I can see Mr. Giral. I don't know if anybody can see or hear me, but
Well, the court can
hear
see you and hear you. I don't know about
Okay.
Mr. Giral. I can see him and hear him.
okay. I think it's working now. I don't know.
It looks like it is. Can you hear Mr. Perkins, Mr. Giral?
I can, Your Honor.
All right, so Mr. Felicia, just raise your right hand. Let me be sure I've got you sworn in. We started over on a couple of times. Do you solemnly swear or affirm all the testimony you'll give before the court today will be the truth, the whole truth, nothing but the truth, so help you God?
Yes, Your Honor.
Do you further solemnly swear all these plea documents which show you signed the document and then sworn to it are being sworn to by you now under oath, freely, intelligently, knowingly, and voluntarily?
Yes, Your Honor.
All right, your indictment's up there on the screen. The state's made a motion to abandon certain portions of the indictment, which the court is granting. So what's left in the indictment, it's right on the screen in front of you. What's marked out has obviously been abandoned. So the indictment now reads as follows. Is presented into said court in the county of Smith and state of Texas prior to the presentment of this indictment, you, Elio Felicia, did then and there, on or about the 29th day of September 2020, intentionally and knowingly commit the offense of unlawful manufacture, delivery of a controlled substance, to wit methamphetamine, in an amount of 4 grams or more, but less than 2 grams. Do you understand those are now the allegations in the indictment charging you with this offense?
Yes, sir.
All right, there's a set of plea documents I'm going to go through here with you. The first one is your agreed punishment recommendation. That's going to be going up on the screen. Disregard that that's up there now. That was from a prior hearing. You've got a plea agreement with the state. If you enter a plea of guilty to this indictment, which charges now first-degree felony delivery of a controlled substance as alleged in the indictment, sentencing range not less than 5, no more than 99 years or life, and a fine may be assessed of up to $10,000. The state's going to recommend if you plead guilty, the state's going to recommend to the court, and I'm going to follow it, that your sentence be assessed at 15 years in the Texas Department of Corrections Institutional Division. That sentence will be assessed with credit for time served. Also, pursuant to Penal Code Article 1245, I'm going to consider on the plea a state jail felony indictment for possession of a controlled substance under 2410245-21. So Mr. Gerald will dismiss that one. Do you understand all that?
Yes, sir.
Is that your plea agreement? Is that your plea deal?
Oh, yes, sir.
Okay, look down the right side of that paper, because there's a signature down the right side of that agreed punishment recommendation. Is that signed Elio Fletcher? In other words, is that your signature?
Elio Fletcher, yes, sir.
Yes, sir. Thank you. It's going to be on all the plea documents. And did you go over each one of these plea documents with your attorney, Mr. Perkins, so he explained them to you where you understood what you were signing?
Yes, sir.
All right, so you got your plea deal. If you plead guilty to the indictment, first degree felony, Mr. Rawls is going to recommend 15 years with credit for time served in the Texas Department of Corrections Institutional Division. I'm going to follow that recommendation, assess that sentence. I'm also going to take that state jail under possession of a controlled substance under 2410245-21 into consideration under Article 1245. That means Mr. Gerald will dismiss it. Do you understand that?
Yes, sir.
All right, your second plea document is an acknowledgement of admonishments. It gives you the full range of sentencing, which have already been over with you. Total of 7 admonishments are just explanations. You and Mr. Perkins, your attorney, have signed below the 7th one. Do you understand all 7 admonishments?
Yes, sir.
The next document's a waiver of trial by jury, signed by you, signed by your attorney, signed by state's attorney. Waiver of trial by jury does what it says. It tells the court that you say to the court, you understand you have a right to a jury trial, whether you plead guilty or not guilty. Do you understand that?
Yes, sir.
And then you say, understanding my right to a jury trial, I knowingly and intentionally give up my right to a jury trial and just ask the court to hear my case on my plea of guilty without a jury. Is that correct?
Yes, sir.
Next document's a waiver of confrontation and agreement to stipulate, signed and now sworn to by you. Do you understand that document?
Yes, Your Honor.
Now, the next document is the stipulation of evidence, states to, signed and now signed and sworn to by you. That stipulation of evidence tracks the indictment. You can see the language in the stipulation of evidence has been marked out, that meaning the state's abandoned that part of the indictment. Same part of the indictment that's marked out earlier on the screen, which the court has approved. Now the stipulation of evidence has that same language marked out. Do you understand that?
Yes, sir.
So what that means is the stipulation of evidence now signed and sworn to by you is a written judicial confession under oath by you to the allegations and the charge in the indictment as it now stands. Do you understand that?
Yes, sir.
Next documents are just an agreement to stipulate evidence on the plea as we're doing. You also signed a document that waives and gives up your right to appeal, and waives and gives up your right to file a motion for new trial. Do you understand all that?
Yes, sir.
All right, now you have gone over all these plea documents with Mr. Perkins where you understand all the plea documents. Is that correct?
Yes, sir.
All right, I'm going to go through and ask you some questions now. It won't take long, but if I ask you any question you don't understand, be sure and tell me, all right?
Yes, sir.
Do you read, write, and understand English?
Yes, sir.
Have you consumed any alcoholic beverage in the last 24 hours?
No, sir.
Are you under the influence of any drug, narcotic, controlled substance, intoxicant, or have any of those substances in your system?
No, sir.
Have you ever been confined in a mental institution or under psychiatric treatment?
No, sir.
You understand everything you're doing in court today?
Yes, sir.
Have you been over everything about the facts of your case, all these plea documents you signed or signed and sworn to, and the allegations and charge in the indictment with your attorney, Mr. Perkins?
Yes, sir.
You competent, Mr. Perkins?
He is, Your Honor.
Any of us of incompetence, Mr. Straw?
No, Your Honor.
Court no state's counsel signed his consent approved of the waiver of trial by jury. Court approves the waiver of trial by jury. All the other waivers in the case signed or signed sworn to by the defendant, signed by his attorney. All right, now you do understand all the allegations, the charge in the indictment, your plea agreement, and all of your plea papers you signed or signed and sworn to. Is that correct?
Yes, sir.
You have any questions for me about anything?
No, sir.
In cause number 241-0578-21, what is your plea today to the offense charged in the indictment for delivery of a controlled substance, a first-degree felony as alleged in the indictment? Like, what is your plea, guilty or not guilty?
Guilty.
Are you entering your plea of guilty to the indictment today because you are guilty and for no other reason?
Yes, sir.
Are you entering your plea of guilty to the indictment today as a result of anyone promising you anything or coercing you, making you plead guilty?
No, sir.
Are you entering your plea of guilty to this indictment freely, intelligently, knowingly, and voluntarily because you committed this offense charged against you in the indictment?
Yes, sir.
Are you entering your plea of guilty to this indictment because you have any type of delusion in your mind or some type unrealistic hope of pardon, parole, or leniency?
No, sir.
Okay, the court does receive and accept your plea of guilty. What do you have, Mr. Jerome?
Your Honor, we would offer states 1, the plea packet with signed waivers and admonishments, states 2, the stipulation of evidence as amended, and states 3, the discovery compliance forms.
No objection to the exhibits is marked and offered, Your Honor.
No objection. States 1, all the plea documents. States 2, the signed sworn to stipulation of evidence, written judicial confession under oath to the allegations in the indictment as amended, and states 3, discover compliance. The court does find the defendant's waiver of his rights, execution of all these plea documents were all done by the defendant freely, intelligently, knowingly, and voluntarily. Further, the court does find the defendant's plea of guilty entered this indictment was entered by the defendant to this indictment freely, intelligently, knowingly, and voluntarily. The court does receive and accept the defendant's plea of guilty to the indictment. The court does find the defendant guilty of the offense of delivery of a controlled substance as now alleged in the indictment, a first-degree felony. Moving to sentencing, Mr. Jerome.
Your Honor, the agreement is for 15 years confinement in the Texas Department of Criminal Justice, and we have 1245, the previously mentioned cause number in 241.
0245.
That's it, yeah.
That's 20. I got it. All right, the court has already, I believe I've already acknowledged it, but I'm pursuant to Article 1245% of the plea agreement, I am taking into consideration on the plea 2410245-21, possession of controlled substance, state jail felonies. That'll be dismissed by the state. Anything else, Mr. Perkins?
None on this case, Judge.
All right, the court, anything else on this one, Mr. Jerome?
And Your Honor, there's a disc that is the digital copy of the written discovery in this case that I will run to the court since I'm off site. I haven't gotten it there yet, but that'll be my evidence for punishment, to support punishment.
That'll be states 4, and it's admitted in when it gets here.
Yes, sir.
Anything else, Mr. Perkins?
No, Your Honor.
All right, the court in this case then, based upon the defendant's plea of guilty to the offense of delivery of a controlled substance, a first-degree felony now is alleged in the indictment, and the evidence presented and admitted into the record by the court. The court finding the defendant's plea of guilty to the indictment was entered freely, intelligently, knowingly, and voluntarily. The court having accepted the defendant's plea of guilty to the indictment, the court does find the defendant guilty of the offense of delivery of a controlled substance, a first-degree felony as alleged in the indictment. Formally pronounces sentence, follows the plea agreement, assesses the sentence at 15 years in the Texas Department of Corrections Institutional Division. No fines assessed or cost ordered pay. Restitution is ordered DPS for the lab fee analysis in the amount of $180 pursuant to Article 1245 as part of the plea agreement. The court has considered, as earlier acknowledged, 2410245-21 for possession of a controlled substance. So the state will dismiss that. Sentence is formally pronounced by the court, finding the defendant guilty of the offense of delivery of a controlled substance, first-degree felony as alleged in the indictment following the plea agreement, assessing the sentence 15 years in Texas Department of Corrections Institutional Division with credit for time served. I've already pronounced the 1245. Sentence is formally pronounced. Mr. Felicia, do you understand I have from you in this plea papers a waiver? Waiver meaning giving up. A waiver that waives and gives up your right to appeal and waives and gives up your right to file a motion for new trial. Do you understand those waivers?
Yes, sir.
Right, they're signed by you and your attorney. You understand by those waivers you're waiving your right to appeal?
Yes, sir.
Are you waiving these rights freely, intelligently, knowingly, and voluntarily?
Yes, sir.
All right, court receives and accepts a waiver of appeal, receives, accept waiver of motion of a right to file a motion for new trial. Sentence is formally pronounced by the court, finding the defendant guilty of the offense of delivery of a controlled substance. First degree felony is now alleged in the indictment. Following the plea agreement assessing the sentence at 15 years confinement, the Texas Department of Corrections Institutional Division restitution order DPS lab for the analysis at $180. Sentence is formally pronounced. Waiver of appeal, waiver of right to file a motion for new trial received, accepted by the court, order filing the papers of the cause. Anything else on this one, Mr. Jerome?
No, Your Honor.
Anything else on this, Mr. Perkins?
No, Your Honor.
All right, the defendant is continued in the custody of the sheriff until such time as he can be transported to the Texas Department of Corrections Institutional Division, serve the 15-year sentence assessed by the court. Following the plea agreement and the recommendation of the state, 15-year sentence, as the court's pronounced earlier, is assessed with credit for time served. Waiver appeal, waiver right to file a motion for new trial received, accepted by the court. Unless there's anything further on this one, counsel, we're in recess on it.
That's it for me, Your Honor. May I be excused?
Yes, thank you, Mr. Draw.
Thank you, Your Honor.
Yes, sir. Have you got another one, Mr. Perkins?
Yes, sir. Peebles is the last name.
Okay.
Bailey Peebles.
I imagine Denise is pulling it.
I've got to wait on downtown to log in.
Who's that on the screen? It says Timmons.
Are you Miss Peoples?
I am.
All right,
Yes,
thank you.
Are you Bailey Peebles?
I am.
Okay. All right, Bailey Peebles, the defendant's present for the court with her attorney, Mr. Robert Perkins. Court's probation officer's present. Imagine Ms. Anderson's coming on here in a minute.
Okay.
No, I don't have Elizabeth.
Judge Skeen,
Yes.
before we begin on Ms. Peebles, I'm just waiting for a call back from the probation department to confirm one detail about her conditions. Could we just hold off just for a couple of minutes while I wait for probation to call me back?
I've got all afternoon. I don't know where Mr. Perkins is.
He looks like he's in the car ready to go fishing.
He's in the car. I just don't know where the car is. So
Well, it's about halfway between work and home,
well, then you're halfway home.
or halfway to work.
Either way. I'm sure Jill's looking for you. That'd be all right.
Well, I'm sorry to hold you up. Before we go on the record, I wanted to be able to confirm one thing with probation. Robert, we're just confirming. I think we're going to ask that she report by phone while she's in Oklahoma at the facility. And we're also going to ask, she can't go up there until she has her intake appointment. That way they can get all her information. They can go ahead and submit the transfer to ICOTS. And then if she's reporting by phone, then she'll know exactly where she's supposed to report and everything upon release, and there won't be any interruption. I just don't want to have any glitches with her going up there or having to come back or not knowing where to report.
Yeah, that's fine. She has an intake appointment, I think at 1 o'clock tomorrow.
Oh, okay.
I do.
Great. Well, I wasn't sure because if she gets released today, I wasn't sure if they were going to want to see her today or what. And then I just wanted to make sure that we were all on the same page.
I think that really it's too far between and not knowing what time she's going to get out of jail. I thought that
to do today.
To get that scheduled for tomorrow.
Okay. And I'm fine with that. I want to confirm that what we're going to do on the back end, like for some reason, if the ICOTS doesn't take her, I want her to be able to know what she's supposed to do upon release from the facility and vice versa. If ICOTS does take her, I want her to be able to be clued in on who she's supposed to report to.
I don't think that's going to be a problem as so long as they'll let her use a phone. You know, some of these places you can't even use a phone, but.
Well, that's true.
I'll have to call and talk to them to see if she's going to have a phone available to her.
Well, if she doesn't have a phone available to her, if they'll just have somebody from the facility where they can at least have contact. Did you check on that, whether they're going to be communicative with how she's doing and the information to the probation department?
Yeah, it's my understanding that that's not going to be an issue.
Okay, so
where's she going?
She's going to a 90-day inpatient facility in Ada, Oklahoma. She has some Indian heritage and she qualifies for this 90-day inpatient program. And so in lieu of going to SafeP, she is going to a 90-day intensive inpatient up there.
Okay.
Assuming the court grants it.
Thank you.
She's Chickasaw Indian.
So that qualifies her for the program in Oklahoma, I bet.
Right, it does. And they have to verify her, I guess, status as a member of the Chickasaw tribe. And that's basically what they're waiting to do. My understanding is verify her Indian heritage so they can accept her into the program.
How do they verify the Indian heritage?
Well, it's funny, Judge. They actually give you a card, which I'm in possession of. And we'll have to get that card to her, and it'll be at the office, and I'm sure she can probably hear us. It'll be at the office at for her to pick up at 8:30 in the morning.
It'll be at the probation office.
No, it'll be at my office.
Okay, thank you. Okay, you understand that, Ms. Peebles?
Yes, sir.
You can hear us okay? All right.
Yes, I can.
So we're about ready to get going now, I think. Probation officers on the screen. Okay. Ms. Peebles, raise your right hand. Let me get you sworn in. Do you solemnly swear the testimony you'll give in the causes now on trial will be the truth, the whole truth, and nothing but the truth? And that
Robert, one question. You said she has an intake appointment tomorrow at 1. Are you talking about in Oklahoma?
Yes.
Okay. Well, she's gonna need, it's going to be pushing it because she's going to have to report probation here before she can go up to Oklahoma. And I don't know if she's going to get released by 5 o'clock.
That shouldn't be a problem. If she gets released sometime today, she can be at the probation office first thing in the morning. The plan is for her to come by my office at 8:30 in the morning to pick up her paperwork, her Indian card, for lack of a better word. We've gotten her property that was picked up at the jail by, I think, her mother or somebody. Anyway, they've returned that to our office. So she's going to have her card that's necessary to do the intake appointment. And as long as she can report, and I didn't know, if she gets released today, she'll go to the probation office today.
If they're still open, she can go today. If not, she needs to be there 8 a.m. tomorrow. And I just want to be clear. She cannot go to Oklahoma before she checks in with probation.
Yeah, I
understand.
We're understanding of all that.
Okay, then I think we're ready, Judge. Thanks for giving me those 5 minutes. I needed it.
That's okay. All right, we're on record in 241-1274-21, State versus Bailey Peebles for possession of controlled substance, more than a gram, less than 4 grams. 241-1275-21, State versus Bailey Peebles on an indictment charging possession of controlled substance. Yeah, again, is alleged in the indictment. Cutilone, methamphetamine in the first indictment, cutilone in the second indictment. In the second indictment, 1275-21 is cutilone in an amount of less than a gram. 1274, of course, is the meth in an amount of 4 grams or more, but less than 4 grams. So, Ms. Peebles, have you been over both these indictments with Mr. Perkins, your attorney, so you understand all the allegations and the charge in the indictment?
Yes, sir.
All right. Now, what we're going to do, we're going to be taking both your pleas at the same time, which will save everyone suffering through me asking the same question twice. You follow me on that?
Yes, sir.
So for purpose of the record, all these questions now from here on that I'm asking you for purposes of your pleas to both indictments. Do you understand that?
Yes, sir.
All right. Do you understand all the allegations and the charge for possession of controlled substance in cause number 241-1274-21?
Yes, sir.
All right. And you understand all the allegations in indictment 1275-21 for the offense of possession of controlled substance. Is that correct?
Yes, sir.
Now, when you look at your plea documents, all of them have a signature on the line above where it says defendant. Is that you'll see some of them coming up. Is that down the right side of this plea?
Yes.
Is that your signature?
It is.
Now, I believe I asked you earlier, but you have gone over all these plea documents you signed or now sworn to with your attorney, Mr. Perkins, so you understand all the plea documents in both cases?
Yes, sir.
All right, we're going to start off with 241-1274-21. In that case, that's 1274-21. In that case, if you enter a plea of guilty to that indictment, the courts will follow the plea agreement assess your sentence at 10 years deferred adjudicated probation. Do you understand that?
Yes, sir.
Also, as part of your plea agreement, the state under 12, well, as a matter of fact, the court under Article 1245 is going to take into consideration in the assessment of the 10 years deferred adjudicated probation recommended by the state a misdemeanor unlawfully carrying a weapon charge, which is not filed. It's under DA cause number 21-03207. So once the court follows the plea agreement, the state's going to dismiss that. They're going to dismiss that UCW. You with me on that?
Yes, sir.
Okay, now over here on your other one, which is in 241-1275-21, that's the one for possession of a controlled substance. Possession of a controlled substance in this 1275-21, that's a state jail felony as alleged in the indictment. It carries a range of sentencing not less than 180 days to more than 2 years in a state jail facility. Fine may be assessed of up to $10,000. You understand that?
Yes, sir.
The state in that one is recommending your sentence at 5 years deferred adjudicated probation. The 5 years deferred adjudicated probation in 1275-21 as part of the plea agreement will be ordered to run concurrent with the sentence recommended by the state of 10 years deferred adjudicated probation over in cause number 241-1274-21. Do you understand all that?
Yes, sir.
All right, now I've got these plea documents. The plea documents vary as far as the charge and the allegations in the indictment, but they're up on one of them. They're going to be both up on the screen from this standpoint. You have a plea agreement, it varies. The plea agreements vary, but if you look up there on the screen, that's the 241-1274-21. Your plea agreement in that one is the state's going to recommend on your plea of guilty 10 years deferred adjudicated probation. Do you understand that?
Yes, sir.
Is that your plea agreement?
Yes, sir, it is.
Like Mr. Perkins, I got off on some of these other things. I did get her sworn in, didn't I?
Yes, yes, Judge.
All right, so 10 years deferred on 241-1274-21. And you understand that plea agreement, Ms. Peebles?
Yes, sir, I do.
Then the other documents I've got in this case, they're basically the same documents in each case, but they vary on the allegations in the indictment, the range of sentencing. But this one right here on the 1274-21 happened to be the one in front of me. That's the state jail felony, okay? That's the one where if you look at your plea agreement on that one, the plea agreement on it, 241-1274-21 is going to be recommended at 10 years deferred adjudicated probation. You with me on that?
Yes.
And that's on a 3rd degree felony. You with me?
Yes, sir.
And I'm gonna follow. So if you plead guilty to the possession of a controlled substance alleged 3rd degree felony, I'll follow the plea agreement, find the evidence sufficient to support your plea, and then I'll assess the sentence at 10 years deferred adjudicated probation. You with me on that?
Yes, sir.
Now over in the other one, 241-1275-21, that is the state jail felony, okay?
Okay.
All right, so your state jail felony, 241-1275-21, that is where the state's, Ms. Anderson's recommended 5 years deferred adjudicated probation on your state jail felony, which carries a sentencing range of not less than 180 days to more than 2 years. In the state jail facility, fine may be assessed of up to $10,000. Understand that?
Yes.
All right, now let me go back over here on 241-1274-21. That is the one where I'm also considering an unfiled DA number 21-0307, but that's the one where the state's recommendations, 10 years deferred adjudicated probation. You with me on that?
Yes, sir.
So you've basically got in your plea agreements under 1274-21, state's recommending 10 years deferred adjudicated probation. I'm going to follow that. You with me?
Yes, sir.
Over in 1275-21, I'm going to follow the recommendation to assess your sentence at 5 years deferred adjudicated probation. Both those probated sentences will run concurrent or at the same time as part of your plea agreement. So you with me on that?
Yes, sir.
Now, you basically have the same plea documents in each case, except they vary as to the charge and the recommendation. I'm just going to go through and identify the plea document, and I'm going to ask you, I'll just ask you right now, have you been over all these plea documents in both cases with Mr. Perkins, your attorney, all these plea documents you signed and now sworn to? Did you go over all the plea documents in both cases with Mr. Perkins?
Yes, sir, I did.
Do you understand all the plea documents that you've got, that you've signed or signed and sworn to in both cases?
Yes, sir.
241-1274-21, the recommendation there is 10 years deferred adjudicated probation. Do you understand that?
Yes, sir.
And you understand what it means to be on deferred adjudicated probation?
Yes, sir, I do.
All right, the next document's the acknowledgement of admonishments. It just gives the full range of sentencing, 2 to 10 years, 3rd degree felony. Fine may be assessed at up to $10,000. Do you understand all 7 admonishments in that document?
I do, yes, sir.
You understand in this case, as well as your other case, both cases you're waiving, giving up your right to a trial by jury. It's probably going to come up on the screen. Your waiver of trial by jury says, it's coming on up. You'll see it. There it is right there. Waiver of trial by jury. You signed it along with Mr. Perkins. Waiver meaning giving up. So you've given up your right to a trial by jury in both cases. Do you understand that?
Yes, sir. I understand.
You waived giving up confrontation with witnesses where Mr. Perkins could confront them and cross-examine them. You've given that up in both cases. You understand that?
Yes, sir, I do.
Both cases you signed and sworn to now stipulations of evidence. Each one of those stipulations of evidence and each cause number is a written judicial confession under oath by you, signed and then sworn to all the allegations and the charge in each indictment. Are you with me on that?
Yes, sir, I am.
You have agreements in both cases to stipulate testimony. In both cases now, you've waived your right to appeal and waived your right to file a motion for new trial in both cases. Are you with me on that?
Yes, sir, I am.
All right. Now, the other documents that I have in both cases, I've got a trial court certification of your rights to appeal. That's already signed by you and Mr. Perkins, but in both cases, that'll be checked by the court Each one of these cases is a plea bargain case, and you have no right of appeal. And it'll also be checked that you've waived, given up your right of appeal in both cases. Do you understand that?
Yes, sir, I do.
So do you have any questions for the court about these plea documents that you've signed or signed and sworn to in either case?
No, I don't have any questions.
All right, 241-1275-21. The first recommendation on the first case is 10 years deferred adjudicated probation. On the second case, the recommendation is 5 years deferred adjudicated probation, and that's going to run concurrent at the same time with the 10 years deferred. Do you understand that?
Yes, sir, I do.
Okay. Do you understand the one where you're 241-1274-21, where you're going on 10 years deferred? That's a third-degree felony. 2 to 10 years in TDC, fine of up to $10,000. So if you violate any of the terms and conditions of your deferred adjudicated probation, the judge of this court would get a violation report that trigger a no bond warrant. And then if you turn yourself in or you're apprehended, there'd be what we call a motion to adjudicate filed by the state. And the hearings would be held in each case. And if the judge, wouldn't be a jury trial, if the judge determined you had violated any of your terms and conditions of your deferred adjudicated probation in either or both cases, the judge would grant the state's motion to adjudicate. This is a big legal word, meaning the court would go back and find you guilty of the offense of possession of a controlled substance, third-degree felony, as alleged in 241-1274-21. That would mean you could receive up to the maximum 10 years in TDC and a fine of up to $10,000 if you violate any of your terms and conditions of your deferred. You understand that?
Yes, sir, I understand.
Over on the other one, 241-1275-21, that's the state jail felony. You're going on deferred adjudicated probation in that one for 5 years deferred. They're both running at the same time. But over here on 1275-21, that's what we call a state jail felony. So in it, you're going on deferred adjudicated probation for a term of 5 years deferred. It'll run at the same time as the other one. If you violate, in other words, as the 10 deferred. If you violate any of your terms and conditions, like failing a drug test, failing a report, whatever it may be, and the state proves it to a judge of this court, the judge would grant or can grant the state's motion to adjudicate in 241-1275, finds you guilty of the offense charged in the indictment. Then in this one, the court could assess your sentence up to 2 years in a state jail facility, fine of up to $10,000. So do you understand the consequences if you violate any of your terms and conditions of your deferred adjudicated probation?
Yes, sir, I understand.
Now, the other side of the road is if you're successful and you complete your terms in each case that you're on deferred adjudicated for, do not have any violations at the end of the term, state will dismiss both the indictments against you, and you will not have a felony conviction on your record for either one of these cases if you successfully complete all of your probation terms for both cases. You with me on that?
Yes, sir.
All right, in both cases, then I've already been over probably 3 or 4 times. I've been over your plea agreements. I've been over your acknowledgement of admonishments, your waiver of trial by jury in both cases, your waiver of confrontation with witnesses in each case. These are all signed or sworn to by you. Just, the stipulations of evidence states to you signed and sworn to in each case. You understand, I'm sure I've mentioned it to you at least once. You understand that's a written judicial confession by you to the allegations in each indictment.
Yes, sir, I understand.
And you've agreed to stipulate testimony. As we've already talked about, you've waived giving up your right to appeal, waived giving up your right to file a motion for new trial in both cases. You with me on that?
Yes, sir.
And I've already told you the trial court certifications will be checked to show both these are plea bargain cases and you've waived your right to appeal. Understanding all of the plea documents, understanding all the allegations and the charge in each indictment, do you still wish to go forward on your plea of guilty to the indictment at each cause number without a jury?
Yes, sir.
All these questions are asked for your pleas in both cases. Do you read, write, and understand English?
I do, yes, sir.
Have you consumed any alcoholic beverage in the last 24 hours?
No, sir, I have not.
Are you under the influence today of any drug, narcotic, controlled substance, intoxicant, or have any of those substances in your system?
No, sir.
Have you ever been confined in a mental institution or under psychiatric treatment?
I have not.
Do you understand everything you're doing in court today?
Yes, sir, I do.
Have you been over all these plea documents, the facts of each case, and everything you're doing in court today with your attorney, Mr. Perkins?
Yes, sir.
Is she competent, Mr. Perkins?
She is, Your Honor.
Robert, you're upside down.
I've taken the position.
I'm upside down.
Yeah,
You are.
You're upside down, and I don't know whether it's, are you standing on your head?
Is your
Sometimes
phone
I
upside
feel
down?
like that, but
Well,
Are you holding your phone upside down?
He dropped the phone earlier, and ever since he picked it up, he's been upside down.
Flip it the other
Really?
way. Will that
It's-
help?
No.
Okay, we're going on.
It didn't
We're
help.
going on. Just stay upside down.
what's so funny is you say that, but I'm completely right side up on my phone.
Oh, wow.
I don't know. I guess somewhere in between where you are and where we are, you got it upside down.
Well, it seems appropriate, but I could try to fix it, but I'm not sure that I know what I'm doing.
Well, I understand that part of it.
I'm completely right side up on my phone, but
Good. Then you're okay. You're
Okay.
right side up on your phone. You're upside down on our Zooms, but we're going on. Okay.
okay. Thank you, Judge.
She's competent, correct, Mr. Perkins? She's competent.
She is, Your Honor.
Any evidence of incompetence?
We're not raising any issue as to competency or sanity in either case.
Good. How about it, Ms. Anderson? Any evidence of incompetence?
None for the defendant.
I'm glad you said that and not me.
If it's competency to work this Zoom app, I will plead incompetent.
We're going on.
Thank
All
you,
right.
Judge.
Now, let me ask you, Ms. Peebles, for purposes of your pleas to the indictments and each cause number, do you understand all the allegations and the charge in the indictment against you in both indictments and each cause number?
Yes, sir.
Do you understand the full range of sentencing and all your plea papers as well as your plea agreements in both cause numbers?
Yes, sir.
Do you have any questions for me about anything?
No, sir.
All right, in cause number 241-1274-21, what is your plea today to the indictment in that cause number charging you with possession of a controlled substance, a third-degree felony as alleged in the indictment?
I'm pleading guilty.
In cause number 241-1275-21, what is your plea today to the charge in that indictment for possession of a controlled substance as alleged in the indictment, a state jail felony?
I'm pleading guilty to that also.
Are you entering your pleas of guilty to the indictments in each cause number today because you are guilty and for no other reason?
Yes, sir.
Anyone threaten you in any way, promise you anything, coerce you, or make you plead guilty?
No, sir.
Are you entering your pleas of guilty to each indictment today freely, intelligently, knowingly, and voluntarily because you committed the offense charged against you in each indictment?
Yes, sir.
Are you entering your plea of guilty to either indictment today as a result of any type of delusion in your mind or some type unrealistic hope of pardon, parole, or leniency?
No, sir.
All right, the court does receive and accept your plea of guilty to the indictment in each cause number, Ms. Peebles. What do you have, Ms. Anderson?
Your Honor, in each case, we offer States 1, the plea packet with signed waivers and admonishments, States 2, the signed and sworn stipulation of evidence, as well as States 3, the discovery compliance documents.
No objection to the exhibits in either case, Your Honor.
With no objection to the exhibits in either cause number, the court does approve and admit into evidence State Exhibit 1, all the plea documents, States 2, the signed and sworn to stipulations of evidence, States 3, discovery compliance. The court finding the defendant's pleas of guilty to the indictments in each cause number were entered freely, intelligently, knowingly, and voluntarily, and that the evidence admitted into the record is fully sufficient to support the defendant's plea of guilty to the offense alleged in the indictment in each cause number. The court does find the defendant's pleas of guilty entered to the indictments in each cause number were entered freely, intelligently, knowingly, and voluntarily. The court receives and accepts the defendant's pleas of guilty. However, the court does withhold a finding of guilt as to the defendant in each cause number. Move to sentencing, Ms. Anderson.
Your Honor, we'd offer a single copy of States 4, electronic copy of the written discovery in this case.
No objection, Your Honor. We've previously been provided with a copy of that.
States Exhibit 4 is admitted into evidence in each cause number without objection. The court then in each cause number based upon the defendant's plea of guilty to the offense alleged in the indictment in each cause number, the court having received the defendant's plea of guilty to the indictment in each cause number, finding each plea of guilty was entered freely, intelligently, knowingly, and voluntarily, the court does find in each cause number the evidence admitted into the record in each cause number is fully sufficient to support the defendant's plea of guilty to the offense alleged against by the state in its indictment in each cause number. However, the court does withhold a finding of guilt to the defendant in each cause number. The court follows the plea agreement and the recommendation of the state in cause number 241-1274-21, assesses the sentence at 10 years, deferred, adjudicated probation, no fines assessed, court costs are ordered paid, restitution is ordered DPS for the lab fee, $180. In cause number 241-1275-21, the court finding the evidence in the record fully sufficient to support the defendant's plea of guilty to the offense possession of controlled substance, state jail felony. The court follows the plea agreement, the recommendation in that case, assesses the sentence at 5 years, deferred, adjudicated probation, order and concurrent with the sentence of 10 years, deferred, adjudicated probation in the other cause numbers. In each cause number, the court has received and does accept and approve the defendant's waiver, giving up a right to file a motion for new trial, waiving also and giving up a right to appeal. Sentence is formally pronounced in each cause number at 10 years, deferred, adjudicated probation in cause number 241-1274-21, and formally pronounced at 5 years, deferred, adjudicated probation in cause number 241-1275-21. Those sentences are formally pronounced. The court assigned the judgment. Let's be sure that Ms. Peebles, I've got my probation officer here. I want to be sure that you understand what you need to do when you book out of jail. Okay.
Okay.
Here's the deal: the likelihood of you booking out before 5 o'clock, slim and none, but it happens. Okay. Obviously, if you book out before 5 o'clock, one of your terms of your deferred probation is you have to go straight to the probation department. You with me?
Yes, sir.
If you book out after 5 o'clock, the probation department closes at 5. So your deferred term reads, if you book out after 5 o'clock this evening, probation is going to be closed. So the term reads you have to be at the probation department no later than 8 o'clock in the morning to report to your probation officer. Do you understand that?
Yes, sir, I do.
Now, of course, probation officer is on the screen. Is there anything else you want to explain to her about that?
Can I actually, before Mr. Duran talks, can I put a couple of things on the record, Your Honor, about her conditions?
Sure.
Thank you. Before Mr. Duran explains the specifics about that reporting, I just want to make it clear that the original offer was for 10 years deferred and 5 years deferred with SafeP. It was the defendant's choice. They offered through her attorney an alternative inpatient program that's located in Ada, Oklahoma. We've agreed to allow the defendant to go there subject to as a condition of her probation, and also assuming that she can stay in Oklahoma if ICOTS accepts her. So she's going to need to do all the paperwork for her transfer, and the probation department will keep in touch with the rehab facility, but it is a condition of her probation that she report to the Women's and Children's Recovery Center in Ada, Oklahoma, immediately upon release, only after meeting with our probation department in person. And then that this is in her choice in lieu of going to SafeP, Your Honor.
Do you understand all of that, Ms. Peoples, just for the record?
Yes, I do. Yes, sir. And yes, ma'am.
All right. What else? Anything else, Mr. Perkins?
No, Judge, just so long as she understands, and I think that the court and the prosecutor have both made it clear to her. I've tried to make it clear to her that if she gets out before 5, she goes to probation today. If not, she goes to probation first thing in the morning at 8 o'clock. And then by the time she's through doing whatever she needs to do at probation, she can come by our office and pick up her property.
Yes.
Okay. Do you understand all that, Ms. Peebles?
Yes, sir.
Thank you. That's
now, it's real important what we've all been over with you. It's real important that I don't think you'll book out before 5, but if you do, you have to go straight to probation. We've all been over it. If you book out after 5, you have to be in the probation department at 8 o'clock in the morning. You know where the probation department is?
I can find it.
Let me get my probation officer to explain it to you in detail. I want to be sure you can get there.
Okay.
Hi, Ms. Peebles, can you hear me?
I can. Yes, sir.
Okay, so our physical address is 217 East Line Street here in Tyler.
Okay.
So it's not that far away from the jail. Are you going to be residing in Smith County upon your release? Let's say if you get out this evening.
No. If I get out this evening, I will. Yes, that way I can report in the morning.
Okay. So yeah. So our address again is 217 East Line Street. As soon as you arrive to our department, you'll go through our security, and then you'll sign in as new from court on our sign-in computer up front in our lobby area.
Okay. Yes, sir.
Do you have anything else, Ms. Anderson?
No, sir.
Anything else, Mr. Perkins?
The only thing that obviously she's never been to our office. Our office is also on Line Street. It's 1 block away from the probation department, so that's pretty convenient for you.
Okay. And you said 8:30 at your office?
That's what time our office opens. I don't think you'll be through with probation by 8:30, but we'll be open from 8:30 on tomorrow. So just whenever you get through with probation, come by the office. We'll give you your card and your wallet.
Okay.
Ms. Peebles, you'll have about 70 terms and conditions of your deferred adjudicated probation. Your probation officer, your supervising officer is going to go over each one of those 70 terms and conditions. You understand me?
Yes, sir.
Here's the deal. As they go through this, they're going to explain each condition to you, and then they're going to say, do you understand this condition? If you say yes, they're going to check a form that says you said yes. Do not sit there and just say yes in answer to the question, do you understand this term, if you really don't understand it. You with me on that?
Yes, sir.
Okay, because if there's a violation report sent to the court, and the judge of this court issues a no bond warrant for your arrest because you allegedly violated one of your terms and conditions, it's going to be too late to come back later and say, well, I didn't understand it, because they're going to have a form that says you did understand it, okay?
Yes, sir.
So don't get in a hurry. It'll take a while, but be sure you understand all those terms and conditions.
Okay. Yes, sir.
You have any questions for the court?
No, sir.
Anything else, Mr. Perkins?
No, sir.
All right, you're right side up now for the record. Anything
I
else?
finally figured it out, Judge.
It's good you are, because you're in your vehicle. That's what had me a little concerned. You might have rolled it. Okay, anything else, Ms. Anderson?
No, sir, just that she understands that successful completion of that program is going to be one of the conditions of her probation, and safe peace not going to be available down the road. So good luck, Ms. Peebles.
Yes, ma'am. Thank you.
Ms. Peebles, you understand all that. What everyone's doing is setting you up in a position where if you just follow all the terms and conditions of these deferred through your term, then when you successfully complete the term and no violations, the state will dismiss both these indictments. But I want to be sure you understand now, you're a young person, you're young in age, that if you violate any of these terms and conditions of your deferred adjudicated probation, a judge, not a jury, a judge would hear the alleged violations, and then the judge can sentence you up to the maximum for each offense. Do you understand all that?
Yes, sir. I understand.
Okay, I don't know what else to tell you. Just remember to report as everyone has told you to do before 5 this afternoon. If you book out before 5, otherwise you have to be in the probation department at 8 o'clock in the morning. If you do not show up, it'll trigger a no bond warrant. You probably won't make it to Oklahoma, okay?
Okay.
All right, we're in recess.
Thank you, Judge.
Thank you, Your Honor.
Thank you.
Thank you.
All right, good luck.
Thank you.